Good morning to everybody. Now we've just lost Galea. Let's see. Let's wait till she reconnects. She was here a moment ago. Let's see what's happened to her. Here we are. Can you open your video?
Hello.
Hello. Good morning.
Good morning.
Good morning, Asayag. Are you there?
Yes.
Oh, good, great. So today we must finish the issue of the open skies, and we have a presentation by Galea of a decision by the court concerning the Commission versus Kingdom of Denmark. Can you, I would say, let's start immediately presentation, so then we can move forward in the course.
Yes, sure.
Okay, I would put it full screen so we can see it better.
Yes, yes. Is it showing now?
Yes, but there's no writing. There's nice. Yes, yeah, it is. Commission of the Year. 1 second, just let me move this slightly. Okay, Galea, the class is yours.
Thank you. So the case that I shall be discussing is Commission of the European Communities as opposed to Kingdom of Denmark. It was decided by the Court of Justice of the European Union nearly 18 years ago, and it forms part of the Open Skies cases. Now, the nature of dispute concerns how the European Union adopted its own discretion when it comes to its external competence with third countries in relation to the field of air transport. In fact, this judgment is considered to be a landmark one because it specifically managed to authorize the European Union to have such discretion. Now, the Commission instituted this case against the Kingdom of Denmark since the latter conducted an open skies bilateral agreement with the United States of America in 1995. And this relates to the notion of alliances. Now, one of the tasks of the Court of Justice of the European Union was that to analyze whether the Kingdom of Denmark could sign such an agreement or not, whether it had the authority to enter into this bilateral agreement on its own with the United States of America, and whether it had and whether this bilateral agreement had the effect of affecting community provisions and Denmark's obligations towards the community. Now, the facts of the case are the following. So, so this is going to be a bit of a historical point of view, and then we move on to the facts of the case. So, by the end of at the end of World War II, several states entered into air transport agreements with the United States. These were called Bermuda Agreements. The Kingdom of Denmark was one of these states which entered into such agreement in 1944. Now, this Bermuda bilateral agreement was amended in 1954, 1958, and 1966. These series of amendments were done in order to liberalize international air traffic. Now, Then, during the 1990s, the Commission worked in order to replace these bilateral agreements by a single agreement between the European Community and the United States of America, in order to have a liberalized internal market in the European Union. Now, in order to do so, according to Article 84, Sub-Article 2 of the Treaty, the Commission had to obtain such permission from the Council. Now, as we might already know, the Council is composed of either the Prime Minister or ministers from each member state. Therefore, since these bilateral agreements were rendering a lot of economic flourishing in the individual member states, they were reluctant to give such a mandate to the Commission. Now, on 23rd February 1990, the Commission requested to the Council for its mandate. Now, 2 years later, 22nd June 1992, the Commission concluded a civil aviation agreement with the Kingdom of Norway and Sweden via the Council Decision 92/384 EEC. And then on the 23rd of October of the same year, the Commission asked the Council once again for its mandate. And this time, the Commission slightly modified its proposal from the one it had asked 2 years before. Now, the Commission asserted that the single agreement with a third country in the field of air transport formed part of the commercial policy of the community, so therefore it had discretion to conduct such a single agreement between the European Community and the United States of America. However, the Council did not approve the requested mandate of 1992, and the motives behind such decline were the following. Now, it mentioned Article 84, Sub-Article 2 of the Treaty. Now, this article embodies the doctrine of implied powers, and it provides the legal basis for the development of an external policy on aviation. Now, nevertheless, according to the Council in 1992, the member states still had their own powers in the field of aviation vis-à-vis third countries. This discretion was subject to the fact that member states should not cease to oblige their duties in the community. In the case that there were to be an agreement between the community and a third country, the Council would only grant its mandate pursuant to the common interest of all the member states. Then, on April 1995, the Commission resorted to the Council's permission for the granting of its mandate in order to reach an agreement with the United States of America on air transport. So the Commission asked for the permission for the third time. On June 1996, however, this time the Council granted to the Commission a limited mandate in these sectors. So on competition rules, ownership and control of air carriers, CRSs, code sharing, dispute resolution, leasing, environmental clauses, and transitional matters. Now, in the case that the United States of America asked to have discretion on a reciprocal basis on relation to state aid, slot allocation at airports, economic and technical fitness of air carriers, security and safety clauses, and safeguard clauses, the Council would extend its mandate to those sectors as well. However, the Council made it clear that the mandate did not include negotiations concerning market access, capacity, carrier designation, and pricing. Now, the Common Declaration of 1996 maintained that whilst the negotiations were still ongoing between the community and the United States of America, the bilateral agreements were to remain valid until a new single agreement would be reached. Therefore, the agreement that the Kingdom of Denmark had conducted with the United States of America remained valid until a single agreement was to be reached. So no agreement had yet been reached with the United States following the conferment of the negotiating mandate on the Commission in 1996. Now, bilateral air transport agreement between the Kingdom of Denmark and the United States. Now, in 1992, whilst the Commission was asking for the Council's permission for the mandate to conclude a single agreement with the United States and the European Community, the US was offering several EU countries the opportunity to conclude a bilateral open skies agreement in order to form alliances between these two states. Now, on 17th November 1994, the Commission informed its member states through a letter regarding the effects that those open skies agreements could have in relation to internal community law. Now, between the 24th to 26th April 1995, the Kingdom of Denmark and the US reached a consensus pursuant to the amendment of the 1944 agreement via diplomatic notes. Now, the Commission's reaction to this. So, the Commission sent a letter to the Kingdom of Denmark maintaining that due to the fact that the community's air transport legislation was aimed at creating a system of rules in order to create the internal market, member states did not have the discretion to enter into such single agreements anymore. Now, the Open Skies bilateral agreement went contrary to primary and secondary community law, and the Danish government reached and challenged the Commission. The Commission sent a reasoned opinion and obliged Denmark to comply with it within 2 months. And then the Commission opened an action against Denmark since it did not approve of the letter's reply. Now, the court's task. The CJU had to analyze if the 1995 agreements had the effect of transforming the pre-existing 1944 agreement into a new Open Skies agreement, incorporating the provisions of the 1944 agreement as successively amended. If the Court of Justice was to confirm this, the court had to review if the 1995 agreement was compatible with the community provisions which were in force in 1995. If it did not confirm with this, then the court had to review if the 1944 agreement was compatible with Article 234 of the treaty. Now, the court ruled that all the international commitments challenged in the principal claim must be assessed in relation to the provisions of community law cited by the Commission in support of that claim, which were in force at the time when those commitments were entered into or confirmed, namely in any event in 1995. Now, what the court did, it divided this query into 3 main questions. And this is the first one. So the court analyzed the external competence of the community within the meaning of Opinion 1 on 76. Now, the Commission opened this action against Denmark on the basis of having infringed the external competence of the community pursuant to the conclusion of the 1995 agreement. The Commission argued that this external competence originated from the necessity within the meaning of Opinion 176 of 1977, which was verified by Opinions 1/94 and 2/92, whereby the community has the discretion to conclude an international agreement even when there is no legislation, provided that the conclusion of such an agreement is necessary in order to attain the objectives of the treaty in that area. And also on the basis of the decision of Commission versus Council, which is also known as the AETR judgment, whereby there were community rules on air transport. Now, the Commission implied that changes in the structure of traffic flows towards the United States of America and allow American carriers to operate on the intra-community market without being subject to all the obligations of the system established by community rules. Then, on the other hand, Denmark's defense consisted of, pursuant to the meaning of necessary in Opinion 1/76, A community agreement on air transport with the United States of America was not necessary, and the community's external competence becomes effective once the community has actually exercised that competence in order to conclude an international agreement. Hence, Denmark could not be sued from concluding the Open Skies Agreement. Article 84, Sub-Article 2 of the treaty does not give discretion to the European Union institutions to negotiate with non-member states. And in March 1993, the Council allowed the member states to continue negotiating on air transport with non-member states. Now, the court's findings on this first query was that the Kingdom of Denmark did not fail to abide by its obligations towards the community when it concluded its amendments in 1995, since there was no exclusive competence within the meaning of Opinion 1/76. Hence, the claim that the Kingdom of Denmark had failed in its obligations by infringing such a competence is therefore unfounded. Now, the second query was the alleged existence of an external community competence in the sense contemplated in the line of authority beginning with the ETR judgment. So the Commission's arguments were the community had created common rules called the third package of air transport liberalization measures, which form the internal market of air transport, and these included regulations 2299/89 and 95/93, which rule on the way that member states should negotiate with third countries. In accordance with these set of rules, the member states do not have the discretion, either alone or with other member states, to enter into agreements on traffic rights and opening access for third country carriers to the intra-community market, since that is the external competence of the community. And the Commission cited from paragraphs 25 and 26 of Opinion 2/91 as a legal basis for these two arguments. Then the Danish counter-arguments were that it confirmed that the third package liberalized the internal market of air transport. However, it is not through this package that the internal market cannot be distinguished from the external market, and the conclusion of bilateral agreements between the member states and third countries did not create an obstacle to the establishment of a properly functioning internal market in air transport. Now, according to the Danish government, exclusive external competence of the community could only exist through three factors. The first one, complete community harmonization in the sector. The second one, the adoption of community rules on the status of persons and companies originating in non-member countries. Thirdly, the adoption of community rules conferring on the community institutions competence to conclude treaties with non-member states. The court's findings were that the Kingdom of Denmark did not abide by its obligations towards the community found in Article 5 of the treaty and regulations 2409/92 and 2299/89. Now, Article 5 of the treaty rules that the member states have the obligation to simplify the community's prime objectives and to refrain from entering into measures which could hinder the latter's goals. The international agreement consisted of airfares, rates charged by carriers designated by the United States on intra-community rules, CRSs offered for use or used in Danish territory. And Regulation 2409/92 specifically hindered in an indirect manner air carriers of non-member countries which operate in the community from introducing new products or fares lower than the one existing for identical products. Community legislature has limited the freedom of those carriers to set fares and rates where they operate on intra-community routes. And Article 1, Sub-Article 3 of Regulation 2409/92, the community has exclusive competence to enter into commitments with non-member states relating to that limitation on the freedom of non-community carriers to set fares and rates. Then paragraph 99 of the judgment states that it follows that since the entry into force of Regulation 2409/92, the Kingdom of Denmark has no longer been entitled to enter on its own into international commitments concerning the fares and rates to be charged by carriers and non-member countries on intra-community rules. The following paragraph stated that it is clear from the documents before the court that a commitment of that type was entered into by the Kingdom of Denmark by virtue of the amendments made in 1995 to Article 9 of the 1944 agreement, which was rewritten. By proceeding in that way, that member state thus infringed the community's exclusive competence resulting from Article 1, Sub-Article 3 of Regulation 2409/92. Also, Articles 1 to 7 of Regulations 2299/89 assert the principle of reciprocity, whereby the regulation applies also to those nationals of third countries in the case of CRS. Hence, the community has exclusive competence in the field of CRS, and Denmark infringed that provision. Regulation 95/93, which is on the common rules for the allocation of slots at community airports, pertains in this case via the reciprocity principle to air carriers of non-member countries. Thus, the community started to have discretion in this field through the introduction of this regulation. So this was another motive why Denmark had infringed these regulations. The Commission did not manage to prove that Article 10 of the 1944 agreement, as amended in 1995, fails to be applied in the allocation of slots. And the last query was the following: the infringement of Article 52 of the treaty. Now, the Commission's arguments were the following. So the clause on ownership and control of airlines went contrary to Article 52 of the treaty. There was lack of clarity on the terms of law and conditions. These have to embody the rights and obligations arising from international agreements concluded by Denmark and third countries. The Danish government counter-argued that Article 52 does not concern those areas embodied by the clause on the ownership and control on airlines, since they relate to traffic rights granted by the American authorities for flights to American airports. Also, the freedom of establishment merely includes the right to take up and pursue activities as self-employed persons and to set up and manage undertakings under the conditions laid down for its own nationals by the law of the country in which the establishment is effected. The answer to the Commission's implication was that the law conveys that the member state of establishment has the authority to dictate those essential rights for such freedom and establishment. The conditions does not embody those favorable circumstances that nationals of the member state of establishment can gain in non-member countries by virtue of previously concluded bilateral agreements. And it is a common customary practice in bilateral agreements
Sorry, Galea, we can't hear you any longer. Sorry, we've lost your voice. The last bullet point, it is a customary practice.
A clause on ownership and control of. Can you hear me now?
Yes. No, once. 1 second, let's see.
Can you hear me now?
Can you go back to that slide? Let's see if we manage to get the slide. The last bullet point.
Okay. It is a common customary practice in bilateral agreements to include a clause on ownership and control of airlines. Now, the court's findings on this was that Article 52 pertains to that area of air transport. It even embodies those airline companies.
Sorry, Galea, we hear you. I don't know, there's some problem with your connection. I don't know. We can't hear you. Sorry, Galea, we can't hear you. Does Apolisa Sayag, can you hear?
Conduct business between, can you hear me now?
Yes.
Sorry, Galea, 1 second. I just want to see if it's only my problem or it's also the other. Apolisa Sayag, can you hear Galea well?
Okay. Yes.
So then it must be, I don't know, it must be my problem because I'm not hearing you well. I don't know why. 1 second, just 1 second, please, Galea. Just let's see what's the problem with me. I don't know, it's strange because I'm connected. I see you very well. And trying to understand why. Can you start again on this last slide, the court's findings? Let's see if now I can hear you.
So Article 52 pertains to that area of air transport. It even embodies those airline companies which are established in a member state and conduct a business between a member state and a non-member state, or when services are directed towards non-member states. Now, the clause on ownership and control of air infringes Article 52. The formulation of in principle, hear me now? Can you hear me? Because okay, because the pictures are not always clear. The formulation of that clause shows that the US is in principle under an obligation to grant the appropriate licenses and required authorizations to airlines of which a substantial part of the ownership and effective control is vested in the Kingdom of Denmark. Community airlines may always be excluded from the benefit of air transport agreement between the Kingdom of Denmark and the United States of America, while that benefit is assured to Danish airlines. So by doing so, community airlines would be discriminated. And the Court of Justice of the European Union finds it irrelevant that normally such clauses of ownership and the control of airlines are incorporated in bilateral agreements. Now, conclusory remarks in relation to this decision. So the Court of Justice of the European Union did not interpret the bilateral agreement as invalid. Neither did it stop the European member states from negotiating bilateral agreements with the United States of America. The Court of Justice of the European Union does not have the discretion to accord the competence to the Commission to conduct such single agreement between the community and the United States of America. As stated earlier, the European Union Council of Ministers had such authority. Instead, the court decided that certain specific provisions and areas covered in the bilateral agreement were contrary to EU law due to the fact that they hindered upon internal EU regulations pertaining to non-EU nationals. And these consisted of allocation of airport slots, pricing, fares, rates of intra-European air services, agreements on computer reserved systems, and provisions which reserve the right to grant permission under the Open Skies agreements only to airlines substantially owned and effectively owned by nationals of the EU member states that are party to a particular agreement. So that was the presentation.
Okay, thank you, Galea. Can you please go back a few slides? There's a central point here, which is essential. No, go ahead. No, go ahead. No, you're going back. Just go ahead.
Okay, so I go in the last slides.
Okay, this slide here. No. The one before, before the conclusive remark. Yes, now. First thing, Galea, this is for everybody. I suggest you always put the page number or the number on the slide, so you know when to find the slide. You go back to slide number 5, 8, or so on, as a general sort of indication, editing indication. To always put a number on the slide. Now, can you please explain better? You pointed out the second bullet point, the clause on ownership and control of airlines infringes Article 52. What is Article 52? What is it about?
So it establishes the freedom of establishment in the internal market.
So can you please, let's start from the beginning. What does freedom of establishment mean?
So okay, so let me explain it in a simple manner. So for example, if there is a company in Malta and it wants to enhance its business, and so it wants to establish a branch in Rome, through Article 52, it has the freedom to establish the branch in Rome.
Okay, so this is freedom of establishment. Just remember, when we just started the course, the first lesson we had on the four fundamental freedoms. Yes. Freedom of movement of goods, movement of persons, establishment, and movement of capital. So this four fundamental freedoms. Freedom of establishment, the fact that a company of one member state can establish itself in a different member state without having any kind of limitation. It can do business. So this is the basic point we start from. Now, why does the Court of Justice say that these bilateral agreements violate freedom of establishment?
Because so this bilateral agreement was between Denmark and the US. And therefore, all the agreement that was done, it pertains to Denmark and the United States. Therefore, if, for example, there will be certain benefits, these will pertain only to the Danish airlines. If, for example, there is a benefit which cannot be benefited by an Italian airline because it does not form part of that bilateral agreement.
So, to put it in practice, let's imagine that Germany does not have a bilateral agreement with the US. A flight that goes from Frankfurt to Copenhagen then cannot go from Copenhagen to the US, or cannot go on the same condition as Scandinavian Airlines, SAS, can go from Copenhagen to the US. So this is the main point, is this. The fact that Article 52 is violated because you are favoring your own national airlines, Denmark, or in this case Danish, that means a Scandinavian airline system, SAS, and you are discriminated against any other air company that from Copenhagen wants to fly to the US. So from substantially, you are granting a privileged, exclusive rights to Danish airlines to fly from Copenhagen to the US. These exclusive rights are denied to other companies, other European companies. But there was also a further element. So it's not only of European companies wanting to fly to the US from Copenhagen, but there was also an issue concerning American companies flying to Copenhagen. What is the implication here?
If I'm not mistaken, I'm not sure about it, but if, for example, from New York, there is a flight to Frankfurt, and then that same airline can go from Frankfurt to Paris, for example. So it will conduct intra-community flights, not international ones.
Yes, well, let's say it goes to Copenhagen and it has certain agreements with the Danish government and therefore has a privileged possibility to go to Denmark. And then from Denmark, it goes to other European countries. So what happens is that, let's imagine Germany is not part of the bilateral agreement. There are American carriers that can fly to Germany through Denmark, taking advantage, sort of piggybacking the agreement, the bilateral agreement between Denmark and the US, while German companies cannot do the same. They cannot say, hey, I'm going to go to Denmark, and then from Denmark, I'm going to go to the US. So there's a double discrimination. On the one hand, you do not have freedom to establish your companies are denied the same equal treatment because if they go to Denmark, if they establish themselves in Denmark, they do not have the same advantage as a Danish controlled company. And at the same time, they are subject to, let's say, quote unquote, invasion by American companies which use the bilateral agreement to enter into their commercial air transport sector. So this is the main. These are the two main reasons for which the European Court of Justice held that these bilateral agreements were invalid. Who else? I mean, this is against the Kingdom of Denmark, but is it only Denmark? I mean, Denmark is a small country. It's nice and nice country, very sort of very civilized. But was it only Denmark? Galea, can you hear me, Galea? I have the impression that